no one can act with impunity.
These are crimes that are beyond the pale.
We are talking about human beings. We're not talking about numbers.
We need a court. That's as simple as that.
This is Asymmetrical Haircuts, your international justice podcast with Janet Anderson and Stephanie van den Berg.
All rise.
Hi, Steph.
Hi, Janet.
So, when is a state obliged to arrest someone for the International Criminal Court? That's the crux of the podcast today on Italy, Libya, and the ICC.
Yeah, on the one hand, it looks really simple. You have an arrest warrant, you are a member state, and hey presto, arrest and transfer a suspect. But as we've seen earlier this year, it doesn't always go to plan.
What we are also seeing seems to be even more than sort of a lack of things going to plan, but maybe a fundamental breakdown in states feeling that they are actually obliged to follow the rules. I mean, we've had Netanyahu, the Prime Minister of Israel, who's currently under an ICC arrest warrant, being told that maybe he's welcome to go and visit Germany and Italy.
We have Russian President Vladimir Putin, who is also under an ICC arrest warrant, who went to Mongolia, even though Mongolia is a member state, and got away unscathed.
So to join us to discuss state obligations, the legal nitty-gritty, specifically around Italy, we have Luigi Prosperi, who's a professor at Utrecht University. Hi, Luigi.
Oh, hi, Janet. It's great to be here. I'm a big fan of the podcast, so thank you for having me.
Before we turn to you, Luigi, we want to map out a bit of the confusion and what is known, what is unknown, what we know that we don't know, and what we don't know that we don't know about Libya, Italy, and the ICC debacle, which is going to be our main focus for today. And to help with that, we have our colleague, our Patreon and newsletter producer, Margherita Capacci, who is also Italian, and she's going to be our Margheritapedia for today because she knows all about Italy and Libya, we think.
Well, to start, thank you for having me. The latest news is that the Italian state has to tell judges at the ICC why they released the Libyan military officer in January. And the story in brief is that on January 19th, the Italian authorities arrested a Libyan man who was under an arrest warrant by the ICC. And then just 2 days later, they released him and brought him back to Libya with the government. And soon after, the ICC asked Italy to explain why they took this series of decisions that led to his release and repatriation. But then February 17th, an official request came, and Italy has a month to respond.
And so that's going to come up soon, and we'll have an update about that at the end of the podcast if there's anything that they said that they haven't said before in those filings. But let's start now by who are we talking about? Who was the suspect?
So the suspect is Osama al-Masri Nim, and he's 45, from Libya, and allegedly the head of the judicial police. And he was in charge of the Mitiga prison in Tripoli. And he's also a member of the main militia in the country, the Special Deterrent Forces, also known as RADA. And so he is suspected of crimes against humanities and war crimes, including murder, torture, enslavement, and sexual violence. And they were committed since February 2015.
And they're taking place allegedly in the Mitiga prison. Why is that name important?
So the Mitiga prison is very notorious and has been the subject of many UN reports over the years, and is notorious for human rights abuses and torture. And it's well known for many migrants and refugees are detained in the Mitiga prison. But I think it's important here to note that migrants and refugees are never directly mentioned in the arrest warrant. But the groups targeted that are mentioned in the arrest warrants are detainees that are held there and they are subject to crimes for religious reasons, immoral behavior, and their alleged support or affiliation with other armed groups. But the sources I spoke to said that the crimes refer to probably migrants and refugees, but not only. This is, of course, a bit of speculation.
And so you wrote several stories about that, and we'll link to those in the show notes for people who want to read what else Margherita has learned from all these sources. What are some of the specific allegations against Najim? What does the arrest warrant say that he specifically did?
So the arrest warrant, which is now public because it was unsealed on January 24th, really gives a sense of the scale of these crimes, so crimes against humanity and war crimes. For instance, it said that between February 2015 and October 24, over 5,000 people were in prison in Mitiga in violation of fundamental rules of international law, and at least 22 people including a 5-year-old boy, were subject to sexual violence in the prison. And at least 8 were subject to rape, and 34 detainees were killed.
So that is a lot of things to mention. Luigi, let's bring you in here. But before we start talking, we'll put a little disclaimer in that in 2021, you worked as a legal researcher for Uprights and helped them draft an Article 15 communication to the ICC concerning crimes committed against migrants in Libya. So we know your affiliations, but that also means you really thought about the alleged crimes against humanity in refugee camps. So we're going to ask you more about that later. But first, we want to tease out, why does the ICC have jurisdiction? Because Libya is not a member.
Yeah, thank you. So there's a bit to unpack here. I hope I will also be able to explain this clearly to our listeners. So there was a resolution adopted by the UN Security Council in 2011, in February 2011, which is Resolution 1970, where they decided, among other things, to refer the situation in Libya from the 15th of February 2011 to the ICC. What does it mean? That under Article 13 of the ICC statute, the ICC, although the state is not a party to the statute, can exercise jurisdiction over this situation. So then you need to define the situation. What is a situation? Well, we have practice from the ICC where basically the most important takeaway, the most important principle is that the crimes that the ICC will prosecute are sufficiently linked to a situation of crisis that you need to define, though. Since in the resolution we don't have a clear scope or the ratione materie jurisdiction defined clearly for the ICC prosecutor, then basically it was the pre-trial chambers that with every request for the issuance of an arrest warrant had to define the situation. And the practice we have, and particularly the Al-Werfalli case that was the first one in, let's say, in a number of cases that we had more recently, let's say, was the first one to deal with the ongoing conflict in Libya. So everybody agrees that basically what happened in 2011 falls under the scope of the jurisdiction of the court. The problem was, as I said, the resolution said from the 15th of February 2011 on, there is no end date. So potentially this can go on forever. So we need to understand what is the situation of crisis. Here you have two options, basically. I think the most easy, the basic understanding is either you stick to the 2011 situation of crisis that was started by Gaddafi and the regime, and you only focus on crimes committed against civilians by Gaddafi and the regime. So that will be the arrest warrants for Gaddafi at the time, before he died, and those for al-Senussi and Gaddafi's son, for instance. And this is what actually the dissenting opinion prefers. This is the option preferred by the Mexican judge.
Yeah, what we have here in this situation is that prosecutor first went after these Gaddafi-linked militias and then decided to kind of broaden it out and take crimes also against migrants with it, and asked for the arrest warrant. And then judges have to weigh every time in this arrest warrant if those migrants can be linked to the central situation. And what we found in the Njim arrest warrant is that there was one judge with a dissenting opinion who thought all these migrant crimes shouldn't be linked to the central situation, and it's something that also muddied the waters, or Italy used as a kind of reason why they felt it was unclear.
Precisely. And if I may, the other option, on the other hand, the one that was chosen by the majority, that is Alapini Gansu and Julia Motok, the other two judges, is an all-female panel, which is also nice to see. And this option basically is grounded in the concept, in the idea that the conflict that started in 2011 is still ongoing. So what is sufficiently linked to the situation of conflict, of crisis, meaning the conflict, is any crime that has a link to the conflict. And now you need to decide how tenuous this link can be. In this decision, what they did was to focus on the role of Njim, El Masri or Al Masri, if you prefer the Italian version, that is, according to the arrest warrant, the director of the Mitiga prison, but most importantly, is one of the members of Rada. And Rada was involved in the conflict since 2011. This is the same, let's say, path that they took in the arrest warrant against Al-Werfalli, where they say, if the person is a member of an armed group that was involved since 2011, we don't need any additional evidence. So that's the point. It's more about the evidence that you need. That's enough for us to say this is linked to the situation of crisis. You mentioned migrants. The problem we had when we drafted, for instance, the Article 15 communication was to decide whether that will be a sufficient link when you have, let's say, for instance, not an armed group directly involved in the conflict, but a group of traffickers, a criminal organization that commits crimes against migrants. Is this sufficiently linked to the conflict? And this was a big problem for us. And in the end, we decided to take, let's say, the most safe, the safest path, where we focused on armed groups that were also detaining migrants.
So when the ICC branched out and looked at these migrants, they also formed part of a joint team with Europol, the United Kingdom, the Netherlands, and Italy. And we want to ask you about the role they've been playing, but we have to also remind listeners that we did a podcast precisely on that in 2023, where Nicole Sampson, who is the ICC's unified team lead on Libya, summarized how this knowledge exchange goes. So then the question to you, Luigi, is what can you say, or what do you know about the ICC's role in that joint team?
Yeah, of course, there's some information available. So this is what I did basically in the past few days. I was also looking into what is publicly available. And I listened to the podcast, of course, where I also learned some things. So this is a joint team. It's a different animal than a joint investigation team that can be created, established between EU member states. They use this different animal under the UNTOC convention. There is a convention against transnational organized crime. So the reason was that they were trying to go after the traffickers that could have been not also members of an armed group that was involved in the conflict. Therefore, they could use the UNTOC, so-called UNTOC convention, and set up this joint team with, including also the ICC, of course, that couldn't join formally a joint investigation team because that comes under EU law, and as well as Europol, the UK. There could have been also a problem with UK not being a EU member state anymore. So let's say we have this joint team for the purpose of gathering information and then eventually decide who's going to prosecute these traffickers. So this was really about trafficking and migrant smuggling, so crimes committed against migrants. This is quite clear also in the public available information.
Well, what's odd to me and to us is that you have all this cooperation between Italy, the UK, the ICC. They have all these connections. Then you have an arrest warrant, and now the Italian government is like, "This is the biggest surprise ever. We didn't know about this."
Let me say two things, if I can. The first one is this situation, this debacle, because I like to call it a debacle. Came as a shock to me personally, and I know also to others that are interested, that are working in this field, colleagues that teach international criminal law, researchers I know from Italy. So it was a bit of a shock. I can speculate here, and this is the second thing that I wanted to say. We don't know whether this Njim or El Masri case actually came under the focus, under the scope of the joint team. It may be that was a separate investigation that the ICC had. On the other hand, I have to say, I find it quite difficult that when you have such a close cooperation with other states parties that you expect to be trusted partners, you don't share information also about other cases. But here I'm just going out on a limb, I'm speculating. So I think that they must have known something, that there was an investigation. The fact that whether they knew that there was a request for an arrest warrant, that the guy was traveling to Europe often, I don't know.
So, Margherita, we're going to move back over to you because we want to have you explain some of the James Bondy stuff to us, because we are hearing very excited. There's secret applications. ICC is tracking him. He's going from Germany to Austria and then back. And the ICC warrant is under high pressure. In days, they have it out. So what do we know? What do you know about that?
So what is known is that El Masri landed in Italy already on January 6th. And he traveled through multiple European countries in the meantime. And he already had a request for an arrest warrant, which was secret at the ICC. And a few days before arriving in Italy, he rented a car in Germany. And he planned to return it in the airport in Rome. And on the 19th, which was a Sunday, he was in Turin to watch a football match. The day before the game, the ICC had issued a sealed arrest warrant for El Masri, and it had transmitted it to 6 European countries, including Italy. And the ICC also said that it conveyed real-time information on his movements, and it had requested the Interpol to issue a red notice. And so on the Sunday, the Italian anti-terrorist police, the Digos, arrested him in his hotel, and it informed the Minister of Justice.
Now, the court says that they told Italy at that point, or when they handed over the arrest warrant, that in case of any problems, they should consult the court. What happened?
Yeah, that didn't quite go like that. 2 days went by, and there was just silence around this arrest. Well, the Minister of Justice sent a note saying that the situation was complicated and they were evaluating how to proceed. Well, the Minister of Justice sent a note to the Court of Appeals and a press statement saying that the situation was very complicated and they were evaluating how to proceed. And the Minister of Justice is the one responsible for dealing with ICC cooperation according to Italian law. But according to Italian law, he is asked to transmit the order. So from what I gather, the Italian law doesn't give him so much power to kind of evaluate what to do. From what I gather, but I'm sure Luigi can say more. And then on January 21st, so 2 days later, 2 days after his arrest, and this is the standard time for Italy to keep someone on precautionary arrest. 2 days later, the Court of Appeals in Rome released El Masri, and they said that he was arrested with the procedural irregularities. That meant that, according to their interpretation, he was arrested without a direct order from the Minister of Justice, which is also has been debated. And so El Masri was very quickly returned to Libya on a government plane, and there he was greeted by supporters. We also the pictures and videos. And I think most importantly, this was all done without giving notice to the ICC.
So, Luigi, some possible problems here and gaps in the story. You wanna take it away?
Yes. So I'll try to really break down the law, the problems relating to the implementing legislation we have in place in Italy, because it's very complex. And if you want, and if listeners want, and they're interested, there are so many blog posts by amazing colleagues of mine that I also want to do an actual shout out to, for instance, Chantal Meloni, that you know very well as younger researchers, Luca Poltronieri Rossetti, Maria Crippa, Matteo Colorio. All of them have written extensively on the problems with the law. I will try to take the easiest path.
We'll link to all of those in the show notes for those who want to get really into the nitty-gritty, but you give us the Cliff Notes version for now.
The law says, Law 237, 2012 says, the Minister of Justice is a conduit, if I have to translate this. The concept is conduit, in the sense he's transmitting the request that he gets from the ICC through the embassy in The Hague. So he receives the documentation from the ICC and literally transmits to the Prosecutor General at the Court of Appeals in Rome, which is the competent court to assess then the request for the precautionary, the pretrial detention. The problem here is we are in a very complex scenario where the court actually asked what in Italian we call a fermo. It's a provisional arrest. So it was a matter of urgency. So it wasn't a fully baked procedure. So we have additional issues on top of the standard issues that you can have with such procedures.
But if you look at what the court has released now, that is the kind of fully baked arrest warrant that we see. So how does that work? Did they first ask provisional and then fully fledged? And is that where confusion is?
Precisely. So there is a very good blog post that will also, I think, link in the podcast notes by Giulia Pecorella. There is another researcher and colleague of mine that works she teaches international criminal law and she does a lot of research in the field. So what the problem is that apparently we have the feeling as international criminal law experts that the Italian judges as well as the minister mixed up two different issues here. So whether Italy could actually evaluate the legitimacy, the legality of an arrest warrant, and what is that Italian authorities have to do to comply with the obligations arising from the ICC statute. So based on the law, it's really not clear, far from clear, whether all of these steps, like the request for the arrest, the confirmation of the arrest, the request for pre-trial detention, are all steps that must be taken after the minister has transmitted. But this is what the judges of the Court of Appeal of Rome accepted. So based on the decision, based on the judgment, they say the legislation, Law 237/2012, requires the prosecutor general to get the documentation from the minister. He didn't, so he couldn't finalize the request for the pretrial detention. Just to make it clear for the audience, for the listeners, especially those that are not Italians. So that's really a problem we have. The minister later, in a communication to the parliament, even used the term, I am not a paper pusher. But this is actually what the ICC statute requires you to be, because you have to cooperate fully with the court. And maybe we'll expand on this a bit later. But he was really adamant, I'm not just a paper pusher. I'm here to check the documentation that I receive, which I take issues with. This position I take issues with, because this is not what the statute requires.
Yeah, because the statute normally is you transfer the person, and then if he has issues with the warrant, his conditions of detention, all that stuff, the jurisdiction of the court, this is what you bring up at your initial appearance. This is what the ICC decides.
No, but also because it would be super problematic if each and every time in the state party there was an additional layer of litigation on issues on matters that relate to the ICC and the ICC statute.
I also really enjoyed the explanation of the Interior Minister, who also told the Senate that al-Masri/Najim was sent back to Libya because he was so dangerous, which is apparently why they had to put him on a government plane. And because you could also imagine that they would just, if there's unclear, you can hold him or you release him, but to Italy, not that you kind of give him 4-star treatment and deliver him back to Libya. So what do you make of that decision?
Well, if I may be a bit bold here, I mean, Piantedosi's affiliation, political affiliation, he was really adamant this is about protecting our borders, this is a government that stands for sovereignty, etc., etc. So they really believe what they're saying, that by sending back the man to Libya, they protected Italians. So this is at least the narrative that they're trying to feed the public with in Italy. And I was in Italy at some point recently, and really news outlets were sort of, spreading these kind of narratives where this is a government that it's really interested in protecting the borders. This is a Libyan issue. We don't want a dangerous man here, etc., so on and so forth. But it's problematic. It's very problematic. If you believe that the guy is dangerous, you can still place him, for instance, under house arrest under the Italian legal system, and you take your time to evaluate the documentation. You can request additional information from the ICC and still, in the end, cooperate with the court.
And does this stance in the very nationalist government, is this also why they are complaining that the arrest warrant only came in English?
This is a fun story. Okay, no, I have to consider there is indeed a provision in the ICC statute, which is Article 87, paragraph 2, if I'm not wrong, that actually prescribes that it is states parties to the statute that in ratifying the statute can submit a declaration where they explain what are the channels of communication with the court, as well as in what official language of the court they want to receive the documentation. Funnily enough, Italy chose French. I didn't know that. I only found out when I was reading about this debacle. To some extent, one could say, well, they received the documentation in a different language than the one they chose according to the statute, so according to international law. On the other hand, I have to say, there is a way to solve this problem, if you want to call it a problem. There's Article 97 that actually instructs states parties to the statute, to seek consultations with the court if there is any problem that may jeopardize cooperation. And this could be considered as one of the problems. So the priority should have been, let's get in touch with the court, let's use Article 97 for urgent consultations, and if the problem is English, which apparently was, because maybe we can also talk a bit more about this, let's have the documents in French. But this is under the assumption that actually they needed the arrest warrant, because there's also people that wrote, Italian scholars that wrote, as well as judges, that this was a different procedure, as I was saying earlier. This was a matter of urgency, so you don't need the actual arrest warrant. You only need a documentation from the court attesting that there is an arrest warrant. And later, you have 60 days, according to the regulations of the court, to provide the state with the full arrest warrant.
We're going into a lot of legal nitty-gritty, and for those who are interested in that, also they should read all the blog posts we're going to link to. Before we kind of move on, because we have to find an end point for this conversation, I want to ask, later in January, the Italian Prime Minister, Giorgia Meloni, said that she'd been placed under judicial investigation together with the Justice Minister, Nordio, and Piantedosi for allegedly aiding and abetting a crime and misuse of public funds. So what is going on with that investigation? And if you know, what do you expect from procedure that is now going on at the ICC, where the prosecutor has also asked that the Italian government is found to be in non-compliance with the arrest warrant? What are the consequences in both those procedures?
This will be pure speculation. I will try to maybe stick to the law. So there are two different investigations, two different paths that we can follow. On the one hand, you have the domestic criminal law instruments. The reason why they are now under investigation is because, in theory, if El Masri or Al Masri, if you prefer that version, commits new crimes in Libya, one could argue that indeed what they did, like sending him back to Libya, amounts to what in English you would call aiding and abetting, a crime. So there are, of course, it's an argument, it's a legal argument we can discuss. But you could say they facilitated the commission of the crimes, and the fact that they knew that the guy was already under an arrest warrant for the commission of crimes that he may commit again in Mitiga prison, for instance, clearly is a very solid point, right? So we know that the guy already committed crimes according to the ICC.
Any crimes he commits from this point on are made possible because Italy didn't detain him.
And they cannot claim, in theory, they couldn't claim we didn't know, because they were under notice, so to speak.
Well, maybe they didn't read English.
That could be another issue that, if you want, we can discuss further, although it's always a huge embarrassment for me when us Italians have problems with English in 2025.
So that's the local procedure. And then what is the procedure that is running at the ICC?
Oh, there were additional news. I don't know if you heard about the request that was filed by two lawyers on behalf of a victim of the crimes that Mr. Njem El Masri is charged with. So, according to this victim, what the Italian government did, and particularly Prime Minister Meloni and Minister Nordio, as well as Minister Piantedosi, could amount to, in this filing, they say it's an Article 70 crime. So it's a crime against the administration of justice of the court. I don't know if I would support this argument, in the sense that if you read Article 70, there is a list of offenses, a list of conducts. It's quite unlikely that this could fall under one of those offenses. On the other hand, what they could argue, following up on what is ongoing in Italy, is that if he commits additional crimes, then what they did may amount to a crime, in the sense that they could be responsible of the same crimes that he commits through a different mode of liability, which will be, for instance, aiding and abetting, you could say, but that's more complicated. But there are other avenues, such as Article 25(3) C and D, which are the lowest, let's say, thresholds for the modes of liability.
And that's the case from the lawyers of victims, but there's also the prosecution request that the judges find Italy in non-compliance. What are the sanctions there? Because with Article 70, you have prison sentences and things like that, and they are for persons, but this non-compliance is for a state. What's the worst that can happen?
Well, the non-compliance procedure can lead, if the pre-trial chamber and eventually an appeals chamber, if there is also an appeals, decide that Italy, first of all, failed to comply with the cooperation request. And second, this failure is grave enough to warrant the referral of Italy to either the Assembly of States Parties of the ICC or the UN Security Council. And Article 87 prescribes that the state party may be referred, or a state that didn't comply, may be referred to the UN Security Council when the situation was triggered by a UN Security Council referral, which is the case with the situation in Libya, as we said.
In Reuters shorthand, I always say that the worst that could happen is a diplomatic slap on the wrist. Would you agree?
Yes and no, if I may, because on the one hand, yes, so far we know what happened with, for instance, South Africa, other countries that failed to comply with the request to arrest al-Bashir at the time, was that they were basically first, let's say, found in non-compliance by a pre-trial chamber, and then after the state challenged the decision, the appeals chamber decided that the finding was sufficient, there was no need to refer the countries to the Assembly of States Parties or UN Security Council. On the other hand, I have to say, we have recent practice in the case of Mongolia, where Mongolia was found in non-compliance by the pre-trial chamber, but there was also a referral. And when they challenged the decision, actually they weren't authorized to challenge the decision. So now they are seeking a reconsideration of the decision. If this fails, that decision is final, meaning they will be referred. So we have like more recent practice where maybe we can also infer that now the ICC is trying to take maybe a stricter attitude towards non-compliance. So I wouldn't say that this for sure will end with a slap on the wrist. Could be worse for Italy.
I'm going to wrap up everything, but we do always ask, and I'm going to turn to Margherita for this, about things that we may have left out and that you really wanted to get into this podcast. And I know you did a very extensive script, so this is your chance to weasel something in that Janet and I have ruthlessly cut out of the script.
I think something I wanted to mention, which is not my perspective, but it's a perspective I collected during my interviews, is also how much this case has meant for victims and witnesses in Libya or of El Masri elsewhere. And the interviews I watched, they were all really upset. And in Italy, parallel to the case by the public prosecutor in Rome against Meloni and the other ministers, there was also a case, like a complaint filed by a victim and witness of his tortures, and also the case that the ICC has been brought by witness by a victim when the prosecutor asked the chamber to refer this matter to the Assembly of State Parties or the UN. They also mentioned the risk that bringing him back poses for the people who testified and his victims, because, well, now they know that there is an arrest warrant, so the ICC was able to collect enough evidence. And so people are collaborating with the ICC in Libya. And what I heard is also that, civil society in Libya has been very, very repressed and targeted. And so they also know that it will be very unlikely to travel again soon and be arrested in another occasion.
I am slightly afraid to turn to you because I think you have a lot more to say. Can you, if there is one thing that we didn't mention, if you can bring up one thing, what would it be?
Yeah, there is one indeed. I was thinking about this, and it's not just optics. We are talking about an international criminal court that was established in Rome, right? The statute is called the Statute of Rome, the Rome Statute. That's very sad. It's not just optics, I think. Sometimes we don't bring up this kind of issues, right? But it's really sad that the country that supported the establishment of the court was so eager at the time to host the diplomatic conference, etc., now is the country that is actually not only not complying with the request. What I found worse in the communication of Minister Nordio to the parliament was that he was also throwing shade at the ICC in a way, because he was contesting the arrest warrant, the contents, whether they did a good job or not in actually writing the arrest warrant and in evaluating the conduct of Mr. El Masri. That I find very sad. So I wanted to actually bring up this.
So we also like to ask Luigi, particularly people like you, law professors, is there a particular case that you would like to share with us that's one of your favorites? Maybe you always teach about it. Maybe you think it's really quirky. Maybe it really annoys you. Just what case would you like to mention?
So there is one that actually I don't mention in my lectures because I really took that almost personally. It was the Seychelles trial judgment at the ICTY, at the with Judge Lattanzi dissenting. And I want to mention Judge Lattanzi because she is not only a mentor to me, but she was really a role model. So it's a good opportunity also to send our greetings to Judge Lattanzi. But that was really sad. I took it almost personally because it was really, can I say, a bad judgment? Like, if you read it, it's just bad.
Yeah, Sešo, for our listeners, is a Serbian radical nationalist politician who was indicted for inciting hatred against, I think, Hungarians in the Vojvodina region and some bits of Croats. And in the end was found guilty of very little things. It was a very convoluted, and on appeals he was granted a very minimal sentence.
That he had already served.
Yes.
He never got back to The Hague. And most worryingly, he resumed his political activities in Serbia as if nothing happened and being a hero.
Yeah, he's absolutely very popular in Serbia for defying the tribunal. We'll link to the case in the show notes. And then our final asymmetrical haircuts questions that I'll ask of both of you. Is there anything that you're reading, watching, listening to that you can recommend? It can be international law related, but it can also be what you do to get away from everything.
Well, not to get away from this, actually. I have a book that I would recommend to anyone because I really loved it. And it's What Strange Paradise by Omar El Akkad. That's really just a wonderful book. I read a lot also about migrants, but I prefer novels. But of course, I could also recommend Sally Hayden's book because it's amazing. And you also interviewed her, I remember, in a podcast. But that's more non-fiction. Talking about fiction, Omar El Akkad is just wonderful.
Margherita, we've dragged you into this podcast and made you do all this work. What do you do to get away from the demands of us doing law, or has this inspired you to read up on international law literature?
No, I'm happy to do this. I found this case really interesting. But I watch a lot of movies. I really love going to the cinema. And the last movie I watched is also one of the best one I've seen in a long time. And it's called Sing Sing. And it's about this theater program in a detention facility in the US. And how there's no of the big tropes about detention units, actually. But it's really just about these men, how they get along with each other, how they share their feelings, how they find a different perspective through their play. And I think the amazing thing is that almost all of the actors in the movie are actually former members of the program who have now left jail.
Wonderful. Thank you so much for that recommendation, and thank you both so much for taking the time and telling us all and the nitty-gritty details and the wonderfully pronounced Italian names of everybody involved. We really appreciate it. Thank you.
And thank you. It was just amazing to be here. Can I send my greetings to my students? I just wanted to also send them some greetings.
Absolutely.
Thank you for having me.
Thank you.
Thank you.
This was Asymmetrical Haircuts, your international justice podcast, created and presented by Janet Anderson and Stephanie van den Berg, in partnership with the Hague Humanity Hub. Music is by Autonautics.com. You can find show notes and everything about the podcast on asymmetricalhaircuts.com. This show is available on every major podcast service, so please subscribe, give us a rating, and spread the word.